Hello and welcome back to our special lecture series on the subject of constitutional law. My name is Taimur and I'm an attorney at law. So today we are going to discuss another important landmark constitutional case, the famous Asma Jilani case. But before we get to this case, I would very briefly walk you through some of the important turn of events that happened in between the earlier judgment we discussed, the State versus Dosso, and the Asma Jilani judgment. The highlight of the State versus Dosso judgment was that the principle of Hans Kelsen, as enunciated by Justice Munir, was that if the constitution or the legal order is disrupted by an abrupt political change not within the contemplation of the constitution, then such a change would be called as a revolution, and the revolutionary government would become the legitimate government, and any order that they give would become the legal order. And so the validity of any laws as such would be judged not with reference to the previous order but to this new order. And so in terms of the Laws Continuance in Force Order 1958, which was promulgated on the 10th October, it was considered that this is the new order, and only so much of the provisions of the late Constitution 1956 which were preserved expressly would be saved. Otherwise, since the new order has come into play, any rights or the cases of people would not be judged with reference to the late Constitution. So after the passing of the State versus Dosso judgment, an interesting thing which happened was that just one day after the detailed judgment was given out, the government of Sikandar Mirza was ousted and Chief Martial Law Administrator General Ayub as such took over. And the same day he resigned as Chief of Army Staff because he was already holding a position of CMLA. And since the Laws Continuance in Force Order 1958 stipulated that the country would be governed as nearly as may be in provisions with the late constitution, subject to any adaptations as may be made by either the president or the chief martial law administrator, General Ayub was given a free hand to make any constitutional provisions as he deemed fit. Now, rolling the clock a bit forward, in the year 1959 he gave his famous Basic Democracies Order of 1959. The conception was that change has to start from bottom up, that there have to be local government elections from union councils, from districts, from villages. And so he constituted pretty much an electoral college constituting of 40,000 basic Democrats from West Pakistan and 40,000 basic Democrats from East Pakistan. And these electors would then in turn elect the members indirectly of the Provincial Assembly as well as of the National Assembly, and later on were also entrusted with the task of electing the president. Now, General Ayub assumed the office of the president, and he held a referendum in the year 1960. The only question which was put to the people was, do you have confidence in Field Marshal General Ayub? And so he won a 95.6 affirmative vote and went on to be appointed as the president for a term of 5 years. In the year 1962, he gave the famous Constitution of 1962. Earlier there was a Constitution Commission that submitted its report, and then General Ayub had his own cabinet give its report, and then on basis of what he deemed as fit, a Constitution of 1962 was given, which was a departure from the parliamentary form of government. This provided for a presidential form of government with a unicameral legislature and so on. Rolling the clock further forward, in the year 1965 there were elections which were held, and President Ayub was then the president of Pakistan Muslim League. He went up against Fatma Jinnah, who was the nominee of the combined opposition parties. However, this was a landslide victory, and General Ayub managed to secure some 49,000 votes from the Basic Democrats. A war took place in 1965, and further rolling the clock forward, coming to 1969, you see Zulfikar Ali Bhutto served as foreign minister from 1963 to 1966. However, in 1966 he resigned. He had differences with General Ayub. He thought he had become too dictatorial. And so he formed his own political party, the Pakistan People's Party. And in 1969, due to so much student protests, General Ayub got sort of disenfranchised with the whole idea. Earlier he had sort of signaled that he would be contesting elections which would be held in the year 1970, but then because of student protest he changed his mind. And so on the 25th of March he bid farewell to the country, handed over the reins, if you may, to General Yahya, who through a proclamation on 25th March abrogated the constitution, dismissed the cabinets, dissolved the respective assemblies, and gave his own PCO, Provisional Constitution Order, on the 4th of April. However, this sort of coup d'etat did not last very long. See, there were other events which were taking place in East Pakistan with Mujibur Rahman. And so Yahya, after assuming power, he promised the nation that he didn't want power and that he would be holding elections as soon as possible, and he held true to his word. He issued an LFO order of 1970, the legal framework order. He also got rid of the one unit policy through one of the presidential orders. And so elections were held on the 7th of December 1970. These were considered by historians to be some of the fairest elections ever held in the history of Pakistan. And out of 291 seats, the Awami League bagged 151 seats, whereas Pakistan People's Party got 81 seats. Mujibur Rahman's demand was that the first assembly, the National Assembly session, should be called. The date was scheduled for 15th February 1971. However, due to his 6 points, one thing led to the other, and the National Assembly session was not called. Tension further grew, and from 25th March to 27th March was officially launched a military operation in East Pakistan. Mujibur Rahman was arrested on the 26th of March. However, on the 22nd of November, Indian forces moved in, and so by the 16th of December, through an instrument of surrender, the Pakistani forces surrendered to India in East Pakistan. However, on the 18th date, there was a coup d'etat in GHQ against General Yahya, who initially wanted to continue as president and continue as Chief of Army Staff. However, this demand of his was never entertained, and so on the 18th of December, he had to resign both as the president as well as the Chief of Army Staff, and on the 20th December, Zulfikar Ali Bhutto assumed and took the oath as president of Pakistan. So in the backdrop of these circumstances, the famous Asma Jilani case takes place. Briefly, the facts of this famous landmark Asma Jilani case were that one Malik Ghulam Jilani, the father of Asma Jilani, was arrested and he was detained under orders purported to have been issued under certain sections of the Defence of Pakistan rules. Against this detention, a writ petition was filed before the Honourable Lahore High Court, and the case was fixed for regular hearing for the 31st of December 1971. However, one day before, on the 30th of December 1971, this order was substituted to have been issued by Martial Law Administrator Zone C under Martial Law Regulation 78. In a similar matter, the editor-in-chief of Dawn News was arrested, detained under similar Martial Law Regulation 78, and so he challenged this detention before the Sindh High Court. Now, in Asma Jilani case, the government of Punjab, also in the Sindh High Court case, the defense which was put up by the government was that due to this new jurisdiction of courts removal of doubts order of 1969, which was a presidential order issued under the PCO, which was promulgated on the 4th of April 1969. The court does not have the jurisdiction to hear any case where an order has been challenged which was issued by a martial law administrator, and their pressing argument was that since in State versus Dosso it was firmly established that if a new order disrupts the previous order, the new order becomes the law of the land, and any rights of people would simply be judged with reference to this new order. And so the 4th April 1969 PCO issued by General Yahya was now sort of the law of the land, and so this jurisdiction of courts removal of doubts order was issued in pursuance as a presidential order under this PCO, and so the courts do not have the jurisdiction. And so the Lahore High Court and the Sindh High Court dismissed these respective writ petitions against the dismissal order, criminal appeals were filed before the Honorable Supreme Court. Now, the issues as such were threefold. The first issue was whether the precedent given in the State versus Dosso was correct. Number two, even if it was correct, whether it would apply to the current facts and circumstances of the case, where General Yahya simply took over power from General Ayub. And number three, that if the source of the power taken up by General Yahya was itself illegal, whether all the legislative executive acts issued under him, including the removal of court's doubt jurisdiction order, whether they would also as such lapse or be set aside. So now the first issue, as far as the precedent of State versus Dosso was concerned, it was observed that this case has been upheld in many other judgments, the famous Mehdi Khan case, and so many, Iftikhar Uddin case, where this principle came up. It was questioned, but it was again upheld. And so based on the principles of stare decisis, it was argued that the State versus Dosso precedent should equally and also apply in the Asma Jilani case. However, the courts ultimately ruled that in criminal matters, fiscal matters, or constitutional matters where the liberty of the person is in question, this rule in stricto sensu should not apply, and that the courts would not be bound by rather their earlier judgment. The Supreme Court is free to even defer at times from its previous ruling if it has given before. Apart from this important principle, the Supreme Court delved into the very premise of the Hans-Kelson's theory. Sharifuddin Pirzada, who appeared as amicus in this case, argued that this State versus Dosso judgment was given in haste. There wasn't given enough time. The short order only came like within few days, and that it was also reported that Chief Justice Munir was involved in the very drafting of the law's continuance in force order of 1958, and so there was apparent bias. The fact that the Hans-Kelson's theory is not a universally accepted theory, it should not be applied. And so after hearing the parties, the court ultimately held that number one, that Hans-Kelson's theory is a pure theory of law which is based on normative norms of what should be done, what should not be done. Second, this is just a juristic's proposition. The most important element of it was the efficacy of change. And the efficacy of change would require that this new order should be accepted by the people. And only then this de facto government could become de jure. However, in the facts and circumstances of the case, only a day after, Sikandar Mirza was ousted by a creature of his own creation. The CMLA displaced him. So how can you say that this revolution has become accepted? And furthermore, the court also held that we cannot give primacy to international law. A principle of international law cannot be enforced as a rule of municipal law by the courts. And so on these reasons, the court overturned the ruling earlier given in State versus Dosso. On the 24th of March 1969, President Ayub wrote a letter addressed to General Yahya, which stipulated that it is your legal and constitutional responsibility to save the country, not only from external aggression, but also to save it from internal chaos and disorder. And so one day after, on the 25th of March, through radio broadcast at about 7:15 p.m. to be precise, he appealed to the public at large to appreciate the delicate situation and to assist the defense forces in any way. Now the question before the Honorable Supreme Court was that after having gone through and examined the letter and the contents of the broadcast, there was nothing in effect which would be construed to President Ayub nominating General Yahya as his successor, or giving up power, transferring or surrendering his power over to General Yahya. Rather, the modus operandi given under the late Constitution 1962 was that the President would hand over his resignation in writing addressed to the Speaker. The Speaker would become the acting President, or even the President could invoke emergency provisions. However, no such action was undertaken by General Ayub. And so now the question was as to how General Yahya simply assumed power. Now on the 25th of March 1969, through a simple proclamation, General Yahya abrogated the 1962 Constitution, he dissolved the assemblies, he dismissed the cabinets. And on the 31st of March 1969, through yet another proclamation, he assumed the office of president, which was to have a retrospective effect, so that he would be deemed to have taken the oath as president from the 25th of March 1969. And so on the 4th of April 1969, he issued a PCO, because whenever a dictator abrogates the constitution, you have to restore some of the provisions and the writ jurisdiction or the judicial power of the high courts or the Supreme Court. And so on the 4th of April, when this PCO was issued, it had the effect of Law's Continuance in Force Order 1958, of restoring some of the provisions of the constitution, restoring some of the powers of the courts, and so. Now the question before the court was that just by issuing a proclamation of martial law, can the constitution be indeed abrogated? Can the whole civil administration, civil law system be displaced by military law? And so the court delved into the very meaning of martial law. And so the court held that in peacetime, martial law would be considered to be some of the statutes which has been enacted by the parliament, such as the Army Act, Air Force Act, Navy Act. However, in war times, it refers to the powers of a military commander over at enemy territory, and that the displacement of the ordinary civil law system through yet another military law system whereby civilians could be tried. However, they refer to a famous ex-party Milligan case, which happened in the backdrop of the American Civil War, when President Abraham Lincoln suspended the writ of habeas corpus and someone was tried, a civilian, through military commission. He was one of the Union dissenters or was part of the Confederates, and so his case made all the way up to the Supreme Court. The Supreme Court said that if the situation has arisen in which the civil courts are still functioning, a civilian cannot be tried by a martial law. And so the court further pointed out that the first question that has to be seen is whether a war situation exists. A situation exists in which the civil courts can no longer function, in which the civil administration is not running. And the court also held that usually a martial law is brought in this country through a proclamation issued, or has to be brought through a proclamation issued by civil government in a situation or in events where a situation has arisen in which the civil courts are not functioning. However, they said that no such situation had arisen, and so they held that the proclamation of martial law does not by itself involve the abrogation of the constitution, the displacement of the civil law, or the fundamental law of the land. Another important case which happened in between was the Mir Hassan and others case, where certain persons were now to be tried by military court. They had challenged the martial law orders before the Honorable Lahore High Court, and the Lahore High Court actually gave its decision in their favor on the pretext that these orders issued by the military were without jurisdiction, and that the High Court could still exercise its writ jurisdiction powers under Article 98, which had been saved by the PCO. But moreover, the court held that the whole concept of martial law, the way it has been proclaimed, would not take effect because the very prerequisites do not apply in this case. And so to nullify the effect of this judgment, this jurisdiction of courts removal of doubts order of 1969 had actually been promulgated. Now, when the court started examining the various provisions of this jurisdiction of courts removal of doubts order, the court firstly pointed out that under Article 3(1) of the PCO, it was stated that so much of the provisions of 1962 Constitution would be saved, subject to any adaptations, additions made by CMLA, Chief Martial Law Administrator, and not the President, which was a contrast to how things were done in the Law's Continuance in Force Order. And since the jurisdiction of courts removal of doubts order, presidential order was issued by the President, who himself was a creation of the PCO, this was dubbed as a sub-constitutional legislation which could not otherwise amend the PCO, which was the Constitution. Apart from this point, the court also examined certain other provisions of the PCO. They said that the court nonetheless has its power to exercise writ jurisdiction under Article 98, which is its prerogative. The court also examined the famous Martial Law Regulation 78 and said that Article 2 was saved by the PCO, which said that no action detrimental to life, liberty, or property shall be taken except in accordance with law. The court also pointed out that there is a difference between jurisdiction and judicial power. You see, earlier the court said that law is something, the definition of law is something which A is given by competent authority and B which can be enforced. And so as a necessary concomitant, the whole notion of judicial power is that the courts have the jurisdiction to see whether they even have the jurisdiction to hear a case or not. So this was a sort of a Marbury versus Madison moment, reiterating what earlier had been held in terms of judicial power from Yusuf Patel in State versus Dosso. They said that this is judicial power which is inherent, it cannot be taken away by a simple statute. And so apart from these grounds, the court also held that since the proclamation of martial law itself cannot involve the abrogation of the constitution, the very process through which General Yahya assumed power over itself is illegal. And so the Martial Law Regulation 78 and the Presidential Order number 3, the Jurisdiction of Courts Removal of Doubts Order, would not be saved. However, in the backdrop of these arguments, one last argument still remained, that if Yahya was a usurper, all the legislative and executive acts would again be set aside, and the famous elections which had been held under LFO 1970 would also be set aside. We would have again a Maulvi Tamizuddin situation. And so the court had to again press in service the famous doctrine of necessity, which was earlier enunciated in the Governor General reference case. However, the court tried to regulate and put certain conditions. They said that only to the extent that it is necessary for the proper functioning of the civil administration, which would not help the usurper, which would not result in impairing the rights of the people. And the most important principle that Chief Justice Hamoud Rahman gave was that the doctrine of necessity would only apply after a conclusion has been reached that the usurper and his acts were illegal and illegitimate. Only once after having considered and having said so, can the question arise as to how many of his legislative and executive acts should be saved, notwithstanding their illegality, in the wider public interest. And so some of the important executive actions were saved under yet again this principle of doctrine of necessity. So we're going to cut short our lecture here today, and in our next lecture we are going to take up the famous Begum Nusrat Bhutto case. Thank you very much.